Go live here. Okay. All right, looks like we're all set. And live stream's running. Okay. Great. Okay, well, let's get on the record. Welcome, everybody. This is docket 9820 CE 100. It's the application for a CPCN Vista Solar for electric generating facility and ancillary equipment that goes with that. My name is Michael Newmark, Administrative Law Judge for the PSC. We're here on Zoom with our pre-hearing conference. We have the applicant and interveners in attendance. First off, let's just get appearances on the record. And I'm going to display the service list I have in the case at the moment, current version. This list will be used for serving documents that the commission issues. We use those email addresses. So I don't know if you've gotten a preview of this yet, but if you can see it on the screen share, any corrections or additions we need to make. Oh, no, hang on, we got one more. Oh, first in here. Okay, so let's start with Clean Wisconsin.
Good afternoon, Your Honor. Brett Cordy on behalf of Clean Wisconsin, and our service list looks correct.
All right. Public Service Commission.
Sophia Rogers, Zach Peters won't be able to join us today.
Renew Wisconsin. Let me get the full list up here. Here you go.
Good afternoon, Your Honor. Ori Walswick with Renew Wisconsin. We also have Michael Vickerman and Andrew Kell on the line with us, and the service list looks correct to me. Thank you.
All right. Okay, Town of Grant.
Good afternoon, Your Honor. Always a pleasure to see you. Town of Grant by Stan Riffle. It's all good.
All right, great, thanks. Town of Plover.
Good afternoon, Your Honor. Shane Vanderwall here on behalf of the Town of Plover, and it looks correct.
All right, great. Doesn't happen often that everything checks out here. I'm surprised. All right, so Vista Solar.
Good afternoon, Your Honor. Alex Peterson on behalf of Vista Solar LLC, and service list looks correct.
Yeah, I'll just scroll down for the rest there.
We got it.
Okay.
That's good to me. Yeah.
Hang on, I just have to. I'm gonna let in one more person here while we get to the list. Sorry, we do have one more to go. Okay, and Wisconsin Wildlife Federation. Get the whole list up here if I can.
Your Honor, this is George Meyer, and representing Wisconsin Wildlife Federation here today, and the list looks fine.
All right, great, thanks. Okay, we'll remove that from the screen share. So it's just the details here listed, but let's get to the meat of the pre-hearing conference. The notice pre-hearing conference lays out what we're doing here today, identifying the parties, issues, schedule, and any other facilitating matters. I do have the parties listed here as we've seen that request to intervene come in. I did want to review those requests. I did not issue an order on the request to intervene just so we could speed up this process. The requests have not been, no response or opposition has been filed to these requests, so I don't think there's really an issue there. But I just wanted to review the request to intervene so that I know a few details about the proposed intervention. So I think the main issue really is I do want to, and like I mentioned in the schedule, I do want to divide direct evidence between the applicant and parties generally in supportive of the project, and then the direct coming later with parties generally opposed to the project, along with commission staff direct at that time. So I do want to get a sense of where parties stood in terms of the application. To the extent they can do so now would be helpful. And so I just wanted to go through each with each request. And I also wanted to point out, I believe, yeah, I really is no issue with this request. I just wanted to make sure that each request does state a reason for why the commission should grant intervention by right or by permission. And it looks like just briefly reviewing the Clean Wisconsin one, it met that requirement. So I was just curious in terms of Clean Wisconsin's position on the application. Can you just generally describe where Clean Wisconsin stands?
Yes, Your Honor. So Clean Wisconsin is generally in support of renewable development in Wisconsin as part of our mission to address climate change and impacts from our current electrical generation capacity in the state. I would note that we also I don't know if you were apprised of the discussions during meet and confer among the parties, but we were in agreement that having all interveners file in the second round of direct would be better. Respectfully, Your Honor, these projects.
Well, let me get to that later when we talk.
Okay, no problem. Yeah, so
kind of curious. Yeah, go ahead.
Yeah, I mean, so just like with other solar facilities that we've appeared before you on, there are sometimes discrete issues related to concerns of ours. In particular, in this case, wildlife issues come to mind where we may not be on the same page as the applicant. So, you know, the best I could say is we're generally in support, but that doesn't mean that we're going to be in agreement on all the issues. And I'll save reasoning for our request for the schedule to be changed for later.
Sure. Okay. And in terms of your presentation before the commission, will it be the typical Clean Wisconsin experts or any outside experts?
We expect Dr. Paul Mathewson to be our expert witness on the environmental co-benefits and also addressing any potential issues with environmental or wildlife habitat, things that come up.
Okay, thanks. So that's kind of I used you as the guinea pig there, Attorney Cordy, but that's kind of the gist of what I was looking for from the parties. Just want to get a sense of lay of the land here when it comes to the interveners. So we could have, I'm just going to go through the order that this is listed on IRF, these requests to intervene. So you have Town of Plover was next on the IRF listing of requests to intervene. So we can just get the town's take on its general perception of the application and then how it intends to participate. Go ahead. I think is that Attorney Vanderwall?
Yeah, it is. Good afternoon, Judge. Generally, we have very much the similar position that Clean Wisconsin has. We're not necessarily opposed to it. However, I'm not going to represent to everyone here that we are in agreement with all of the positions, and it sort of depends upon how the direct evidence comes in as to what portions, i.e. wildlife issues, that may become pertinent. But we're not opposed in general to the project.
Mm-hmm. Mm-hmm. Okay.
And obviously, as you're aware, we're working on or trying to work with the applicant towards a joint development agreement, which would then significantly limit our position, and we would present that to the court as well. So.
Okay, perfect. And in terms of expert witnesses or any idea?
Yeah, we're looking into that right now. We may have a lady from UW Stevens Point.
Okay.
And I just so you know as well, we would take a position that is fairly consistent with the town of Grant.
I see.
To the extent Mr. Riffle adds anything different, you know, the town of Plover and the town of Grant are fairly lockstep in their positions in this matter.
Okay, great. That's good information. Okay, thanks. Yeah, so let me check the next one off our list here, which is the town of Grant. So that's a good segue. We'll present their request to intervene. So this one did pose little bit of a quirk here. I understand that the town, I think we can assume some of what the town, in terms of the town's interest in the case, but there is no interest necessarily, stated in the request. And I think in order for the request to be valid, I do want to hear and just have on the record the town's stated interest, whether it's its basis for a right to intervene or right to seek permissive intervention. So I'm going to start off my questions for Attorney Riffle with just to state your state the town of Grant's interest in the case.
Your Honor, there was a subsequent document that was filed that indicates that we believe we have a right to intervene as a matter of right in that the largest portion of this proposed facility is located in the town of Grant.
So you're talking about the amended notice?
It's not amended. It's a notice of request to it. It's irrelevant because our position is that we have concerns with regard to planning and land use, in that the town has adopted amendments to its long-range land use plan as it relates specifically to the footprint. And there are considerable concerns that are very, very attendant to that related to environmental and wildlife impacts associated with this. We do anticipate that we would be calling the town planner, who was instrumental in putting together the amendments to the town's comprehensive plan. And we do intend to work very, very closely with the Wisconsin Wildlife Federation. I do not believe that we will need to hire any additional experts, but I believe the Wisconsin Wildlife Federation, in my consultation with Attorney Meyer, has 3 or 4 experts that will be involved here. We will be working together with the town of Plover and WWF to compile that into I think a joint presentation, so that you won't have, multiple and disparate experts that would be weighing in on some of the very, very important wildlife concerns that are impacted with regard to where this particular facility is proposed. And additionally, the town of Grant is also working with the town of Plover and the county to try to come up with a coordinated JDA. And as Attorney Vanderwall had indicated, if that all comes together, we all may be singing Kumbaya by the time we get to your decision making.
Okay, well, hope springs eternal. So, and just to square the circle here, do you find the town of Grant generally opposed or generally supportive, or it's kind of, I know you gave me a few reasons there, but you're muted.
I turn myself off, which I should do more often. But at this point, with regard to this exact proposal, we are not. Who agreed with me?
Vanderwall.
We got a court reporter trying to record this down, so let's.
At this point in time, we are opposed as it is presently presented before the PSC.
Okay, all right, thanks. Okay, and so I did want to touch base on just a couple of points that you made, Attorney Riffle. First of all, so we'll get into this with the facilitating matters, but I think probably the reason why I did not see your other filing is because it was probably filed as correspondence on IRF. Whereas looking at the request to intervene, I'm looking at these documents filed under that particular document type, request to intervene, or request for intervention is actually what it's called. So the facilitating matters that's attached to the notice of pre-hearing conference, same one will be attached to the pre-hearing conference memo. And by virtue of it being in the pre-hearing conference memo, it's going to be ordered in the case. So that's going to be the best guide we have for formatting and filing documents. Please review that document, everyone involved. Make sure that you have, to the best of your ability, use the format and filing instructions. That'll really help facilitate the proceeding, especially because I have about 5 of other cases running at the same time, multiple parties, multiple filings coming in. So please, and we can review some of those. I'm gonna review some of the common pitfalls before we adjourn. But just wanted to point out that that's why doing it according to the normal process is it's very useful for everyone here. So let's move on to next party, Renew. So
Yes, Your
Renew,
Honor.
I think I have enough information in your request, but if you could just go through those questions I've been having, the position on the application and how you wish to participate.
Sure. So we actually have another request to intervene, which is more extensive. This was just a request to update the service list, but generally Renew would be in support of the project. We're a nonprofit dedicated to advancing renewable energy in Wisconsin. That includes solar power and energy storage. And this project is going to be one of the largest solar projects in the state. Also, there's this storage component, and there's been Renew is very interested in the siting of that. We plan to present the testimony of Andrew Kell here in this proceeding. Mr. Vickerman will be stepping aside in April, so Mr. Kell's testimony will be taking over and might be a titch different than what Renew has offered in the past.
Okay, and just I'm assuming it's a generally supportive, but you mentioned it sounded like because the battery storage is a new issue, or you're supporting?
Yeah, we're generally supportive. Like I said, this is the biggest project in the state. It's pretty nuanced as far as what the correct way forward is. So I think it's fair at the time as the application sits to categorize us as in support, but positions can change, and certainly agreement on one minute issue or disagreement is up for debate there still yet.
Par for the course. Yeah, I understand. Okay. All right. So I believe our last intervener is up, and let's
Your Honor, George Meyer with the Wisconsin Wildlife Federation, and has been discussed. Our position is nuanced or complicated as some of the other parties. As a large advocacy group for wildlife and formed by over 200 sports clubs throughout the state, we have a very strong position in favor of renewable energy because of the impacts of climate change on the wildlife. That is our mission to advocate for. But we do have concerns about, I would say, the design and some of the features of it as it impacts wildlife and outdoor and other recreational use of the adjacent wildlife area, the Buena Vista wildlife area. And so it is nuanced, but we would like to see some changes that some may perceive minor or major to the project. As far as witnesses, we will have several. Two of them, and these would be shorter witnesses. We have over 200, as I mentioned, sporting organizations. One is a major landowner up there, the Dane County Conservation League, and we're representing their interest. They're joining with us on that, and they definitely will be testifying. There's another organization that has a similar interest as that and has been involved with us in this matter, and would have a representative of that organization testify. In addition, I have, and this could expand, two individuals for sure and probably two more dealing with various aspects of the wildlife issues with different expertise in some cases, one for some of the issues, and then two of them about the major issue of the greater prairie chicken, which we'll all learn a lot more about. In addition, there will be a firearm safety expert, I believe, will be testifying because this is a recreational area with hunting, and that is at least one of the issues we raise. I would say we would be somewhere in the 68 witness area, but two of them being very brief for sure. And I think that pretty well covers it, Your Honor.
Okay, great. Yeah, actually, please be comprehensive with that. I was actually curious about recreational effects. We haven't had a case where recreational impacts have been this front and center. So a case yet, let me clarify, a case yet with solar generating facilities. So this would be very useful to have presented to the commission. So I did want to just pick your brain a little bit, Attorney Meyer, about, I think Attorney Riffle mentioned that you may be coordinating with other parties, working with your witnesses, with your experts. And I just wanted to give you guidance on that in terms of filing those witnesses, presenting and offering those witnesses. I think if it would be useful just in terms of organizing the filings, labeling matters, citation matters, if the witnesses that WWF is going to be sponsoring remain within your sort of rubric of the filing format. And then if another party wishes to adopt that testimony or support that testimony, it can do so. But this way, just in terms of labeling the testimony and who's sponsoring the witness, it would be from a single party. My sense is that probably the Federation will be sponsoring the bulk of those, and maybe some additional witnesses from the towns. But that would just be able to simplify the formatting and filing process. So does that make sense for everyone?
I fully understand and agree with that.
And just one other point, I think, and just may be simply semantics, but Attorney Riffle mentioned joint testimony. So this may not be what he meant, but just in case it was, if someone wishes to file testimony of two witnesses in one filing, we discourage that. So we have some history with like panel filing testimony. Not as useful as it may appear. So to the extent we can avoid having multiple witnesses filing together, I would encourage we separate witnesses with their own filings, and then they take the stand, and they're subject to questions on their own. We can ask the same questions of more than one witness, or we can reserve questions. We can recall witnesses back to follow up. In case we're missing a point that maybe one witness understands something more than another, but it's better than having joint witnesses and more than one witness taking the stand at the same time. Sometimes that just leads to a lot of confusion on the record. So just want to point that out. So commission staff, did you want to add anything in terms of the staff's participation?
Nothing to add at this time. We have some thoughts on the schedule.
Okay, all right. So let's move on then, and we can talk first about the issue, which is our standard issue, kind of just encapsulates everyone's concerns. That's the intention anyway. Certainly not meant to limit anything beyond the scope that the commission needs to review. So any comments or concerns about the issue? No? All right. So we'll use that issue. Schedule. Sounds like there are some problems with that. I did, and actually I do have something I need to put out right away, which is the August 14th date was an oversight on my on my part, and I apologize for that. I work counting absentee ballots for the city of Janesville. So that's going to be happening on the 13th. Usually that work doesn't end well into the night, maybe even the next morning. So I don't think I'm going to be able to be conducting a hearing the next day. So I did want to propose to move push that out at least a day. The Thursday is usually a commission meeting. So we try not to hold big hearings on the same day. So I was thinking possibly the August 16th for the party hearing session. So I wanted to present that right away, but we can talk about the rest of the schedule and get people's views on everything. So I know there was some concern about what we've been starting to do is to divide the interveners with supporting interveners going first and opponents going second. It doesn't sound like there's some, hard and fast opposition to this project, and it sounds like most interveners are sort of generally supportive with many concerns or possibly, seeking some conditions or modifications. So I'm open to changing that if necessary. I just wanted to get everyone's view on that. I can start with the applicant first, probably, and see what Vista Sands thinks about that.
Yeah, Your Honor. This is Alex Peterson. On the hearing date, I think we would need. So we're going to be obviously presenting a significant number of witnesses, and so we need to check with them to make sure that they're available for that updated hearing date. We went through our proposed witnesses and the people who we think are going to be testifying and cleared the 14th with them. But I would imagine, it's not too far of a difference. I would imagine if there was vacation, complications, that we probably wouldn't implicate a couple days later. But just want to get your thoughts on the process for, us making sure that our witnesses are available for that date. Given that we didn't have an opportunity to do that before today.
I understand. Yeah, I just realized this. Well, is it possible to have, how long do you think it'll take for you to confirm?
If I really get on people, I mean, probably early next week, but that's just a guess, but yeah.
Okay. Yeah, this document, we don't have to set this immediately. So yes, let's shoot for Wednesday for people to get back to me with if the 16th is even, working for us now, if we can agree to that tentatively, then just get back to me by Wednesday. If you just want to email Attorney Rogers on that, and then I can just set the schedule at that point.
Okay, that makes sense to me as an approach to tentatively set the date for the 16th, and then we can let you know, Attorney Rogers, to make sure everybody's available. And as far as the dates for direct testimony goes for interveners, I know that Renew had expressed some concern about their ability to file direct on the 14th of May. And also there was some concern from the parties about, based on some of the nuanced positions that some of these parties the interveners have about declaring themselves supportive or opposed. And so I think the applicant supports moving all the interveners' testimony back to June 18th, that as proposed by Renew and that we discussed in the pre-hearing conference email chain.
Okay. Yeah, and just so you know, I'm not privy to the email meet and confer. So, okay. So, anyone else want to comment on that?
Your Honor, would you like us to check on availability for the 15th and the 16th, or just go for the 16th of August at this point?
Yeah, I think if we could shoot for the 16th, that would be the best.
Thank you. And then just to add a bit on the timing, I do expect, I could see with some of the major potential wildlife issues being well known to the applicant and others at this point. I could imagine some direct coming in from the applicant that would address some of those issues right away. I don't know for sure, but I think in this case, for that reason in particular, it would make a lot of sense to move all the interveners to the second date of direct.
Okay. Well, I'm prepared to do that. If anyone else is just going to reiterate that, you can avoid you can avoid commenting. So yeah, we'll just make the all interveners on the 16th of the June 18th. All interveners and commission staff direct. Any other questions on the schedule? So just so you know, if the hearing date does shift, then all the remaining dates will shift for the same number of days. So we'll have transcript won't be due until 2 days after the party hearing session's over. The rest of the deadlines will just shift by, in this case, would be the 2 working days.
Judge, I don't have a question. I just want to make sure that everyone knows to email both me and Zach Peters, who's the lead in the docket. I'm covering for him today, but he needs to be included as well.
Yeah, okay. I don't know if he'll be available by Wednesday, but yeah, just cover your bases and email both of them. Thanks. All right. So nothing else on the schedule. Thanks. That's great. So facilitating matters, like I mentioned, they're tedious and boring, but they're very important. So especially for people who have not practiced or haven't practiced before the commission in a while. There has been a number of this version is January 16th of this year. This version of the FMO. So there is a change that if you haven't practiced here very recently, you wouldn't have known. I'm not going to look it up exactly at this point, but the gist of it is there used to be a requirement so that we had the record set in stone when we received it, that no hyperlinks be included in testimony and exhibits, so that people don't have the false assumption that a link is also, and what gets retrieved by clicking on that link is in the record, because it's not in the record. So what I would make parties do, many of you are very familiar with this, is they had to edit every link so that it wouldn't actually forward to the internet or somehow disrupt the link. Even in exhibits, so for example, like the clean energy plan, the governor's clean energy plan has like 15,000 links, and they all have to be somehow sanitized. So we've forgone that requirement and simply have you place a disclaimer. So for exhibits, that disclaimer goes on the cover page, so that just to remind everyone, all links included in this document are not record evidence. And in terms of testimony, if you're citing to something, the link is to be used as a reference point, but it's not record evidence. So it's useful, for example, if parties want to communicate to their colleagues, to other parties, saying, I got this information from this link, but the information is only going in the record by virtue of the statement of the witness. The link is not directing the commission to other information. So I've seen where this has where this really does reduce a lot of work and is much more clear. I've also seen where parties have maybe misunderstood or have not applied it correctly. So just be sure to look at that. Actually, I can probably just pick that out quickly. Maybe. Yes. Okay. So in terms of testimony, you'll see it on page 4. So only documentary evidence expressly offered and duly received for the record will come before the commission. Therefore, the first citation to a source other than publicly available case law not offered as an exhibit shall contain the following disclaimer. Any information contained in this citation based solely on this citation is not record evidence. And And you can shortcut that using the acronym NRE in subsequent citations. So that just gives you a little bit of a check on that. And then same idea, page 9 for exhibits, like I mentioned on the cover page, you'll have that disclaimer. So that's really important. And you know, the real consequence for misfiling things is they'll make you file it again, but no one likes that. No one wants to do that. So, so for other details, sort of common pitfalls that I think we should just, I'd like to review briefly, is format. First of all, when you're filing a document, like I mentioned, you want to use the correct IRF document type, and I have the ones that are most used in contested cases listed. So you want to make sure you're using, I don't have testimony or exhibit. I don't have testimony on here. Look at that. So you want to make sure you're using the proper document type. And then also when you're filing testimony, this can get tricky, but we have a nomenclature, a naming convention for how you number the pages on testimony. So we said on page 6, and then the name you give the file on IRF as well. They're very similar, but they have some nuances, and it's explained here. So similar situation is presented for exhibits, how we want to name exhibits. So that information's in the FMO. You can contact probably Zach at that point, or maybe maybe Sophia for the commission attorney for more information about that. If you have questions, if they don't know the answer, they'll refer it to me. So those are some common things that trip people up and require a refiling. It's not following the nomenclature that we have set up. Otherwise, I did want to also review, I think there's something we need to back up here. The hearing itself, the party hearing session. So I wanted to get parties' view on whether we do the party hearing session Zoom or at the commission's hearing room. So I'm open either way. There's certain pros and cons for doing that either way. So if parties do feel strongly doing an in-person hearing, we can do that. If parties have strong inclination to do a Zoom hearing, we can do it that way. So any opinions about the format of the hearing itself?
Your Honor, this is Alex Peterson from the applicant. I think our preference would be a Zoom hearing just for the ease of coordination of getting people in the same room. Might be a challenge in terms of the number of witnesses and whatnot, and also the attorneys and such. So I think just based on people's comfortability with Zoom at this point, I think that'd be our preference, but open to hear other suggestions.
Yep, me too. So anyone else? No. Yeah, it does sound like we will have a number of witnesses, so that does make some sense to do it on Zoom. So we can, we'll put that in there for now. If someone does have, yeah, anyone else? No. Okay. So we'll put that our party hearing session as Zoom. Now the public hearing session will be in person in the location of the project. We'll have to find, I have it to be determined because it really depends on getting a facility that will accommodate us. Our public hearing session is conducted in person and over Zoom. So we just have to make sure we have internet connection, enough room to seat everyone, et cetera. So, so that's still to be determined, but we will get a facility as close to the project location as we can. Okay, sorry about that, a little distraction there. I think I was done with the facilitating matters, unless people have questions about that, anything in the facilitating matters order. Now, this isn't official yet until I order it in the pre-hearing conference memo. So we can discuss modifications or anything, take any comments people have. No, all right. And I did want to also review something that's come to my attention in the latest several solar generation cases, that the applicant does file, as a matter of course, a number of documents that are created by outside experts. In some cases, we've allowed the applicant, a representative from the applicant, to verify those documents. And sometimes we don't really verify, don't really end up verifying them, I think, per se. They're just kind of accepted. But I do wish, and especially in this case where it seems to be some very, minor technical issues that may be actually bigger, maybe points of contention, that the applicant do present and offer those appendices through its witnesses and have them verify them. So I have the list of the application here. So there's a number of appendices, the standic exhibits, and the economic impact analysis, the property value analysis. If we could have witnesses appear and verify those documents. I'm willing to leave it up to you. I think if you want to maybe have the witness just file a brief introduction for those documents, just to say, I created this, I filed it, it's what it is, and then that just gives us a placeholder. So if we can file a very brief, direct testimony introducing that document, and then they can just take the stand and verify it, that would be useful. Trying to find the actual.
So, Your Honor, would that be similar to how you would introduce just an exhibit, just kind of referencing it at the beginning of testimony and saying, this is I created this, or my firm created this? That's kind of what you're expecting.
Yeah, I think that's generally the case. I think it's a little concerning to me that I think the economic analysis and the property valuation study, they actually have authors to them. I think a lot of the other appendices, we used to see like the engineer or the actual author's name on those studies. I don't really see that here anymore. So it just says the firm name. So I think we just want to make sure we have someone who can verify that they've they're familiar with it. They have some sort of basis to say it's true, and then have them make that statement that it's complete and correct.
Understood.
Yeah. Okay, good.
One quick follow-up question, Your Honor, about maps. I know there's a number of maps in the appendices to the filing, and so I was wondering what your thoughts on those were. Would it be this just a general statement that, I guess I'll leave it to you, and how to verify those.
Right. Yeah, I don't think we need to get into the maps per se. I think if it's just basically the studies that I see, so to pick one out is like the cultural resource report, endangered resource review, and if maps are attached to a document, so to speak. I know they're filed separately, but they're but basically the appendices are what I'm mostly concerned about, that they get verified by someone who has some expertise in the area, rather than just having the representative of the applicant just verifying everything. Because I think, like, even with our EIS, you'll see the particular staff person saying, I worked on chapter 3, and then they take the stand and they don't necessarily verify the EIS, but they're taking the stand and they're stating what their contribution was. That's probably good enough. I think in this case, especially with the Stantec
Stantec
reports, right? Stantec reports. I mean, I guess what's most concerning is we just don't even know who worked on the, oh, here's this one signed, actually. One of them is signed. Okay. Well, some of them don't have a name at all. So I guess that's where I'm mostly concerned about. So I mean, if there's questions, we can look into that more, but I think just to be mindful of that, it could be that and there may be a way to shortcut this, but I would like to have some sort of verification for those documents.
Understood. Thanks.
Okay, and another thing with the facilitating matters kind of links up to these application documents. So you'll see what we call special exhibits in the and I don't know if we actually label them in this version of the FMO as special exhibits, but the idea is we do have a number of exhibits that it's just a way of compiling documents that are on IRF and then offering them for the record. So for example, the application is filed as application on IRF. They're not filed as exhibits. So they haven't been offered for the record until we have the applicant compile them all in a list called the application exhibit, and that gets offered. And basically all that is a listing of those exhibits, listing of those documents with the IRF numbers and links to IRF, so that commission's reviewing the information. It doesn't need to go to IRF and figure out which documents are in the record and which aren't. They're listed on that exhibit. So you'll see a number of those documents, one of them being the application, the other one being the data request responses to staff data requests. And there's a special way to cite to those documents in testimony. So if you are citing to the application Appendix L, facilitating matters order will show you how to cite to that. And the applicant should get that exhibit in with its, I think it's actually 1 week before its direct is due, that should be filed. And then we can all use that document for citing purposes. Commission staff, the data request response exhibit, again, the FMO will tell you how to cite to that. Because this is a CPCN, all data request responses will be part of that exhibit. So you can, even if the commission doesn't have the exhibit filed yet, assume that if it's a data request response to staff, it's going to be in that exhibit. And if you want to cite to it, use that convention. Otherwise, if you're trying to cite to a party data request response or discovery, you need to file it as an exhibit. So that's the difference between staff and the parties. But so if there's a particular data discovery response you want in the record, that needs to be filed as an exhibit. So we'll take it from there. So just be careful about certain things can be cited to using these special exhibits, these lists. The EIS is another one. But the FMO will show you how to do that. Okay. So is there anything else we need to discuss? All right. Yeah. Who's that? Oh, I see.
And I'm new to this process.
Yes.
There may be a very simple answer to this. Currently, the staff of the PSC working with staff at DNR are preparing the environmental impact statement. And what I'd like to find out is the schedule for that, and then how it interacts with the schedule that for the administrative decision-making process. And if there's some way we can try to bridge those two or get them so we can understand that interaction.
Yes, okay. Thank you for that. Yeah, we tried to combine the review of the EIS and the review of the application in one process. So the hearing should be scheduled in a way that it'll meet the requirements for the public hearing needed for the EIS. And The, I don't know if, Attorney Rogers, if you have a, understanding of when we think the EIS will be completed.
I can get that for you.
Yeah, I think the idea is the intention is that it will be completed and we'll have the 30-day comment period before the hearing in the case. So we will coordinate that to make sure we meet the standards in PSC 4. And I don't know if I answered your question or not. That's
I could conceive it. Possibility that may affect what testimony is submitted. And I'm just wondering how that process would interact with testimony preparation.
okay. Well, usually we try to get the EIS in with staff's direct testimony. There have been some times where that hasn't necessarily panned out perfectly, and that the EIS would be issued maybe perhaps like a week later. In that case, we would have, if necessary, we could have a separate round of testimony to address only the EIS. So we would keep the schedule the same for the regular rebuttal, but we could have an opportunity for supplemental rebuttal to meet so that you can respond to the EIS in particular. We try our best to get that EIS testimony and get the EIS submitted with staff direct. So I'm assuming that that's going to happen. But I will keep you posted on that too. Yeah, go ahead.
Yeah, I'm told the plan is April 29th for the draft EIS, and then the final EIS will come later.
Okay, so at least you'll have the draft. Yeah.
Thank you.
Okay. And
Sorry, April 29th. I think I said the wrong day. April 29th for the draft, and then the final is going to be July 25th.
okay, that late, huh? Okay.
You know what? Something's wrong with me today. I have jet lag. July 15th,
Yeah.
April 29th, and July 15th.
15. Okay.
Could you repeat that, please?
Yes. The draft will be issued April 29th. The final would be July 15th, and this is our tentative internal schedule. We can coordinate further over email on confirming availability for the hearing dates, but that's staff's tentative plan.
Thank you.
Okay, good. Yeah, and just so you know, the comments to the EIS, that's used for staff purposes. So that might be something that's maybe different in other agencies. So we are putting out the draft EIS for comment, and then the final EIS goes out for comment. That's really separate from the record that we're creating. It's used for, well, I guess okay, I think that's probably the best way of describing that. So if you do want to enter a comment into the record, it needs to be offered as an exhibit. But usually that's in your testimony anyway. It's going to be something you want to talk about in your testimony. Obviously, you don't need to be a party to comment on the EIS, so that's a separate process that's used for staff to create the EIS. Right, yeah. So the comments. So the EIS will go out in July. I think by that time we'll have. Yeah, by that time we'll have the hearing. We'll be accepting comments for the record at that point. So comments that come in on the final will be part of the comments that go into the record. Any other questions? No? All right, so just give me your answer on the hearing date, the August 16th date, by Wednesday of next week. And once we have that settled, I'll issue the pre-hearing conference memo. We'll have all this nailed down, and we'll get the hearing notice of hearing out as soon as we have a public hearing location. I think that's all we need to do now. Anything else we need to address before we adjourn? No? All right. Thanks very much, everyone. We're adjourned. Take care.
Thank you, Your Honor.
Your Honor.
Thank you.
Thank you.
Bye.